Are you allowed to add people to your newsletter without their express written consent? Let's talk to everybody's favorite IP and entertainment lawyer, Tony, to find out more.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called The IP Professor that is dedicated to all things intellectual property.
Tony, let's talk a little bit about email newsletters. We often find that people are just randomly subscribing us to their newsletters. Is this something they can legally do?
So I'm going to say yes and no, but we'll kind of break down how we got to that point. So I think the best place to start is with the Can-Spam Act of 2003. This is legislation that President George Bush, W. Bush rather, had signed into law that basically created obligations on the FTC front to essentially lay out how brands, how entities that are in the business of selling services, products, what have you, how they basically gather and garner information from consumers and how marketing emails are sent out to them. So we basically, in a way, sort of regulate and put a can, no pun intended, on all the spam emails that a lot of people tend to get, on a frequent basis, but especially around 2003, almost at the dawn of the internet era, with email really flourishing, we started seeing a lot of these spam emails coming through. So the Can-Spam Act was one way of basically addressing the issue of, how do consumers regulate the number of emails they get from marketing newsletters, from product, bulletins, whatever it is. That said, the way the Can-Spam Act was written to, it could allow. It wasn't expressly addressed, but it essentially had this loophole that it could allow brands to add consumers to newsletters without their consent, or could even be a scenario where, let's say, a sister partner of the brand could also have that person's information signed up to that sister partner's newsletter. So essentially, it's almost like the transfer of private information, email in this case, being disseminated across the board. And you're probably wondering, like, how could this be? Think about all the times that you go to let's say like Macy's.com, or when you go onto Sephora or Best Buy or any other website, normally you'll see like a little checkbox that will almost like feel like you're accepting certain terms, like you're accepting payment methods, but you may not realize that part of that is you opting in to, like, let's say, a marketing newsletter or something like that. So unfortunately, that feels like very consumer fraud heavy, but I think that's personal and subjective to each person. That said, what we are seeing, thankfully, is a lot more states stepping up to the plate and actually protecting the rights of consumers. So I think the hallmark example is California with the California Consumer Privacy Act. They have really put forth probably the landmark, the hallmark standard for protection of private information. And in the more recent amendments of that Privacy Act, they've basically laid out certain provisions that would protect consumers. And in this case, what they have implemented now is the right to know about the personal information a business collects about them and how it is used and shared, the right to delete personal information collected from them, with some exceptions, of course, the right to opt out of the sale or sharing of their personal information, and the right to non-discrimination for exercising their California Consumer Privacy Act rights. So this is a win for this, for consumers in the state of California. And we are going to see more states, I believe, kind of defect from the Can-Spam Act, which is good law, but it's worthy of amendments. And I think states at this point have kind of done their part in protecting the rights of their citizens. Now, that said, if you're a brand, if you're in the business of sending out newsletters and you've done this before, I think that there are sort of words of caution that I would give you. One, be mindful of where your people, the people that are listed on your newsletter, where they're domiciled, meaning where do they claim their primary residence? Are they in the state of New York? Are they in the state of Texas? Are they in the state of California? Maybe in Florida, there aren't as stringent privacy rules as there are in the state of California. So you have to be mindful that you're going to have to be in compliance of not just one state, but all states' rules on privacy rights. And for that matter, that gets to my second point, which is regardless of whether you're catering to your local business and you're catering to a very small sub community of people, or you're a national brand, this is your caution to not do the kind of thing that is common in this day and age, which is the selling of private information. Regardless of whether there's a rule in place or not, you have to remember that everyone is entitled to right of privacy. And by sharing that private information, that's no different than sharing someone's social security number or someone's birthday or any sort of private information that only the person really has that privilege to share. They waive the privilege. They're at the point of disclosing. It's my choice to decide if I want to share when my birthday is, but or my social security number, but I'm not freely allowing that right to everybody else. So all that to say, if you're a brand, if you're a service provider and you're in the business of newsletters, just don't do it. Don't sell private information. It's not right. And at the end of the day, it actually could get you in a lot of trouble with the FTC. Probably could get you into some big trouble with state attorney general's offices if it becomes a very prevalent and consistent issue. And obviously, it goes without saying that this could even affect even consumer activity abroad with the EU GDPR. I mean, there are umpteen problems here. So I think it's better to be a bit conservative, play it safe, and kind of do the right thing. Only send newsletters to people who actively sign up for them.
And we always love to have a double opt-in to make sure people truly are opting into that, because if you do come up against some kind of lawsuit, you will need that information. You're going to need that somebody actively chose to join your newsletter and you didn't just add them to it. It could work strongly in your benefit to make sure all those things are aligned inside of your newsletter. If you want to have further conversations on your newsletter and how to do it on the legal side, go ahead and drop those down below. We've got lots of episodes on doing newsletters inside of your business that you can check out in our playlist as well. But if you also have upcoming questions on things that you're doing inside of your business that you do not necessarily need to go directly to your lawyer to find out, which is always a good idea, you can drop them here for Tony. He's coming back for upcoming episodes. And as always, you can reach out to Tony on his social media. Tony, where can everybody find you?
You can find me on Instagram, YouTube, and TikTok at the IP Professor. And you can check out my entertainment law podcast called End Scene, with new episodes dropping every Friday on Apple Podcasts, Spotify, or wherever you listen to podcasts.
Drop your questions down below. Tony's coming back for upcoming episodes, and we're dropping daily videos to help you navigate the world of entrepreneurship to keep you legally, ethically, and creatively protected and make this your most profitable year ever with the least amount of stress. We'll see you in the upcoming episodes.